There's a knock at your door. You look through the peephole. Men in tactical gear. A badge that says ICE. Your heart stops. What you do in the next 30 seconds will either protect every person inside that house or hand federal agents legal permission to walk through that door and take whoever they want. Every single day across America, people answer that knock the wrong way. Not because they're reckless, because nobody told them the 5 things that can legally end an ICE home visit on the spot. They open the door, they answer questions, they see a government seal on paper and assume it's a legal order they have to obey. They're wrong, and that mistake costs them everything. I've spent years studying Fourth and Fifth Amendment law and reviewing immigration enforcement cases. I've analyzed Supreme Court rulings and federal court decisions going back decades. I've identified 5 exact legal moves that protect you during an ICE home visit. Miss one and you hand agents the... And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. Legal foothold, they need to come inside. Use all 5 and the Constitution stands between you and that door. This is educational content only, not legal advice. Always consult a qualified immigration attorney for your specific situation. Trick 1. Opening the door. The mistake. There's a knock. You hear ICE. You want to seem cooperative. You don't want to look like you have something to hide. So you open the door. That one action just changed everything. The scenario. Agents are outside your home. They say they just want to talk. You open the door, you step to the side, they step inside. Now they're in your home. Now they're looking around. Now they're asking everyone in the room for identification. You didn't realize it, but the moment you open that door wide, courts can interpret that as consent to enter. And consent to enter is a doorway to everything that follows. Why people do it? People think being cooperative protects them. They think refusing to open the door looks guilty. They think federal agents have the power to come in regardless. So they open it to avoid conflict. Legal reality. The Fourth Amendment to the United States Constitution guarantees the right of the people to be secure in their houses against unreasonable searches and seizures. In 1980, the Supreme Court ruled in Payton v. New York that absent exigent circumstances, the threshold of the home may not be crossed without a warrant. That protection belongs to everyone inside, citizens and non-citizens alike. Federal courts have consistently held that the Fourth Amendment applies to all persons within the United States, regardless of immigration status. Evidence problem. The moment you open the door and step aside, agents can argue you gave voluntary consent to enter. Consent eliminates the warrant requirement entirely. Your open door becomes the legal foundation for everything that follows. Officer psychology. Agents use soft language at the door. We just need a moment. Can we come in? We have a warrant. The word warrant is designed to make you believe they have legal authority to enter. Most people open the door because they think the badge settles it. The correct move. Here's trick 1. Do not open the door. Speak through it. You are legally permitted to stay inside with the door closed and communicate through it. Say this. I am exercising my Fourth Amendment right. I do not consent to entry. Say it calmly. Say it clearly. Keep the door closed. Why it works. Without your consent or a valid judicial warrant, agents cannot legally cross the threshold of your home under Payton v. New York, 1980. Keeping the door closed is not obstruction. It is the exercise of a constitutional right recognized by the Supreme Court for over 4 decades. Bottom line, never open the door. Say, I do not consent to entry, but keeping the door closed only protects you as long as you understand what's on the other side of it. Because agents will hold up a document and tell you it's a warrant. Most people seeing that seal believe them. There are 2 completely different kinds of warrants. Only one of them requires you to open that door. Trick 2. Treating an administrative warrant like a judicial warrant. The mistake. An agent holds a document to your window or slides it under your door. It has an official seal. It says warrant at the top. You assume they have the legal right to come in. You open the door. You just made the most common legal mistake in an ICE home visit. The scenario. The agent says they have a warrant for someone in your home. You see a government form. It looks official. It has a name on it. You think a warrant is a warrant. You open the door because you believe you have no choice. And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. Why people do it. Nobody teaches the difference between a judicial warrant and an administrative warrant. People see a government document with a seal and a signature and assume it's a court order. It almost never is. Legal reality. A judicial warrant is signed by a federal judge or magistrate. It is the only type of warrant that authorizes entry into a private home under the Fourth Amendment. ICE uses two types of administrative warrants, Form 200, a warrant of arrest for immigration violations, and Form 1205, a warrant of removal for people with final deportation orders. Neither is signed by a judge. Both are signed internally by ICE officers. In a 2007 letter to the United States Senate, then DHS Secretary Michael Chertoff stated directly that a warrant of removal is administrative in nature and does not grant the same authority to enter dwellings as a judicially approved search or arrest warrant. ICE's own basic training materials as recently as 2021 stated that a warrant of removal does not alone authorize a Fourth Amendment search of any kind. A federal court in California ruled in 2024 that ICE agents may not enter homes without a judicial warrant. Evidence problem. If you open the door believing an administrative warrant was a judicial order, you created a consent to enter record. The distinction between warrant types is the hinge on which your entire legal protection turns. Officer psychology. The word warrant carries enormous psychological weight. Saying "we have a warrant" causes most people to comply immediately. The agent doesn't need to lie. They do have a warrant. They just don't tell you it's not the kind that legally opens your door. The correct move. Here's trick 2. Ask them to slip the document under the door or hold it to the window. A judicial warrant will say United States District Court at the top. It will have a case number and a judge's signature. An ICE administrative warrant will say Department of Homeland Security. It will show Form I-200 or Form I-205. No judge's signature. Then say, "This is an administrative warrant. It is not signed by a judge. I do not consent to entry." Why it works. You have correctly identified that the document does not meet the Fourth Amendment standard for entry into a private home. You are not obstructing. You are asserting a protection grounded in decades of Supreme Court precedent and affirmed by multiple federal courts. Bottom line, look before you decide. If it says Department of Homeland Security and not a federal court, I say this is an administrative warrant. It is not signed by a judge. I do not consent to entry. And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. Now you haven't opened the door. You've identified the document. But agents are still outside asking questions. Where is your family from? How long have you been here? Who lives in this house? And here is where people collapse their entire legal protection with one sentence. Trick 3. Answering questions through the door. The mistake. The door is closed, but an agent asks, "Is anyone undocumented in the house?" Or, "Where were you born?" Or, "Have you ever been deported?" You answer, you want to clear things up, you want them to leave. Every word you just said can be used against you in immigration proceedings. The scenario. The agent says, "We're just trying to confirm something. Can you tell me who lives here?" You name the residence. Or they ask, "How long have you been in the country?" You answer, believing honesty is protection. Those words are now part of the record. You didn't open the door, but you talked your way into serious legal exposure anyway. Why people do it? People believe answering honestly makes them look innocent. They believe silence looks suspicious. They believe cooperating will make agents leave faster. That pressure is powerful and real. Legal reality. The Fifth Amendment protects every person from being compelled to be a witness against themselves. In 2013, the Supreme Court ruled in Salinas versus Texas that silence alone is not enough to invoke this protection. You must explicitly claim it. No person, citizen or non-citizen, is required to answer questions about immigration status, nationality, or how they entered the United States during an encounter with federal law enforcement. Evidence problem. Every statement you make through the door can be used in immigration court. Admissions about birthplace, entry date, or prior removal history can give agents probable cause they did not have before you spoke. Your words build their case. Officer psychology. Agents ask questions that sound conversational but are investigative. Just a quick question. I need to confirm one thing. This is not small talk, it is evidence gathering. Every answer closes a door on your legal defense and opens one for them. The correct move. Here's trick 3. Do not answer questions. Invoke the Fifth Amendment explicitly. Say this. I am invoking my Fifth Amendment right to remain silent. I will not answer questions. Say it once. If they keep asking, repeat it. Do not explain. Do not add anything. Why it works. An explicit invocation is legally documented. Unlike silence alone, this on-record statement establishes your constitutional protection. If agents continue questioning after an explicit invocation, your attorney has grounds to challenge how any responses were obtained. Bottom line, never answer questions through the door, not one. Say, I am invoking my Fifth Amendment right to remain silent. I will not answer questions. You haven't opened the door. You identified the warrant. You said nothing. But agents are still outside and minutes are passing, and you don't know if you're legally being detained inside your own home. That uncertainty is not accidental. Not knowing how to resolve it is trick 4. Trick 4. Not asking whether you are legally detained. The mistake. The agents are still at your door. You're not sure if you're being detained or if this will end. You wait. You say nothing. You don't ask. And that silence keeps extending an encounter that may have no legal basis to continue. The scenario. The knock was 20 minutes ago. Agents are still there. No judicial warrant has appeared. You haven't spoken. But you also haven't asked what is legally happening. Every minute you wait without asking is a minute where the encounter is voluntarily extended on your part. And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. Why people do it. People assume law enforcement controls when an encounter ends. They don't realize that without a lawful detention, they have the right to understand their legal status and to document that no lawful basis for the encounter exists. Legal reality. In 1968, the Supreme Court ruled in Terry v. Ohio that brief detentions require reasonable articulable suspicion of specific criminal activity. In 2015, the Supreme Court ruled in Rodriguez v. United States that law enforcement cannot prolong an encounter beyond its legal purpose without new and independent justification. A consensual encounter, one you are not legally required to participate in, can be ended. But you must know which type of encounter you are in. The only way to know is to ask. Evidence problem. Remaining passive for an extended period can be characterized as voluntary cooperation with a lawful encounter. Your passivity becomes evidence of consent to the duration. Officer psychology. Agents understand that most people will wait indefinitely out of anxiety. The longer the encounter continues without legal challenge, the more momentum it builds. The wait is a tactic. The correct move. Here's trick 4. Ask directly through the door. Are we being detained or are we free to end this encounter? If the answer is no, you are not detained. Say, then I am ending this encounter and stop engaging. If the answer is yes, ask, on what legal basis are we being detained? That forces agents to state a specific, lawful reason on the record. Why it works. This converts a vague, pressure-filled encounter into a defined legal interaction where obligations are on the record. If agents cannot articulate a lawful basis for detaining you, your attorney has grounds to challenge anything that follows. Bottom line, never wait in silence. Say, are we being detained or are we free to end this encounter? At this point, you've protected yourself at every step. But there is one more opening. Because agents don't only try to reach the person at the door, they try to reach anyone inside. And one unprotected voice can undo everything. Trick 5. Letting anyone inside speak without protection. The mistake. You stayed silent. But someone else walked to the window and answered when an agent called out a name, or a family member opened a side door, or someone called out from another room. One unprotected voice inside that house dismantles everything. The scenario. Agents have been outside for 20 minutes. A family member, scared and wanting it to end, answers through a window when an agent calls out their name. Or someone says, Nobody here is undocumented. Said in fear, said in innocence. But that statement just confirmed information agents did not previously have. Why people do it? People inside are scared. They act independently without knowing what has been said or refused at the front door. They don't realize their words carry the same legal weight. Legal reality. Every person inside a home has the same Fourth and Fifth Amendment rights as the person at the door. In 2006, the Supreme Court ruled in Georgia versus Randolph that where one occupant is physically present and expressly refuses consent, that refusal controls even if another occupant attempts to consent. Consistent, unified refusal from all occupants creates the strongest possible legal record. Evidence problem. A single statement from anyone inside, a name, a confirmation of residence, an answer about status, can give agents probable cause they didn't previously have. The protection built at the front door can be dismantled through a window on the other side of the house. Officer psychology. When a primary contact doesn't engage, agents may try to reach a secondary contact, they may call out names, they may approach other windows or doors. Reaching a more anxious occupant is a known strategy, the correct move. Here's trick 5. Every adult in your household needs to know these protections before you ever need them. Designate one person to handle the door. Everyone else stays back, stays silent, and does not approach other entry points. If no preparation was possible, the person at the door must say loudly, "Everyone inside, do not speak. Invoke your right to remain silent." Say it loud enough that it is heard both inside and outside. That creates a record that the objection was communicated to everyone simultaneously. Why it works. The Fourth and Fifth Amendments are strongest when exercised consistently by everyone in the home. A unified, documented refusal from every occupant gives your attorney the most powerful record to work with. Bottom line, an ICE home visit is a household event, not an individual one. Protect everyone. Designate one speaker. Say nothing. Here's the truth about an ICE home visit. It is a legal encounter where every action either protects or exposes the people inside your home. The Constitution does not reward those who talk. It rewards those who know where the law stands and how to invoke it. Here are the 5 tricks one more time. Trick 1. Do not open the door. Say, "I do not consent to entry." Trick 2. Look at the warrant. If it says Department of Homeland Security and not a federal court, say, "This is an administrative warrant. It is not signed by a judge. I do not consent to entry." Trick 3. Do not answer questions. Say, "I am invoking my Fifth Amendment right to remain silent. I will not answer questions." Trick 4. Force legal clarity. Say, are we being detained? Or are we free to end this encounter? Trick 5. Protect everyone inside. Designate one speaker. Make sure every adult in your household knows these phrases before you ever need them. Write these down. And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. Put them somewhere every person in your home can find them. Practice them out loud. Because when there is a knock at your door and your heart is racing, you will not have time to think. This is educational content only, not legal advice. Consult a qualified immigration attorney for your specific situation. Share this with everyone you know. Post it. Text it. Put it in every family group chat. Because everyone who lives in the United States, citizen, green card holder, visa holder, or undocumented, deserves to know what the law actually says before they need it. The people who are protected are not the ones who talk their way through a federal encounter. They're the ones who know exactly which words to say, when to say them, and when to stop talking entirely. Know your rights. Use them. Share this before someone needs it.